All right. Hello, everyone. My name is Magara. I'm an employment solicitor and I work at Magara Law. I am humbly joined today by Kaleem Mahmood, who's a health and safety associate at CMS, and Yemi Magara, who works in local government as an environmental health officer. So today, the subject title is What the Health? And principally, the focus is on health and safety with an employment law perspective as well. And Kaleem and Yemi and I will be guiding you through this to help leaders, managers, business owners, those in HR and recruitment, and the list does go on because this subject can affect each of us. You're welcome, of course, to ask any questions either in the chat or indeed leave them till the end. Really look forward to having a brief discussion. But with further ado, I'm going to let Kaleem say hello in his introduction, then a brief pass on to Yemi for her brief introduction, and then we will start the webinar. So, Kaleem, please do introduce yourself.
Yes, thank you, Roy. Good afternoon, everyone. So, as Roy said, I'm an associate at the global law firm CMS. I specialize in environment and health and safety. I deal with contentious and non-contentious issues. So, lots of kind of advice around trials and incidents where people get their hands chopped off or lose a limb or someone's died in the workplace. But I also do lots of compliance advice as well, so assist businesses to stay compliant and on the right side of the law.
Thank you. Yemi, over to you.
Excellent. Hello, good afternoon, everybody. Delighted to have you with us. My name is Yemi Magara, indeed, as Roy said, and I am a chartered environmental health practitioner. I specialise in health and safety and food safety. I currently work in local government, but have worked in the private sector too. So right across both worlds effectively, and I'm looking forward to sharing some insights with you this afternoon.
Thank you very, very much. All right, without further ado, I'm going to pass on to Kaleem.
Great. So thank you, Roy. What the health? I'll today be speaking to you about kind of the employer's duties. I'll go through a case study. I will, sorry, next slide, Roy, please. Yep. I will then go through what the individual's duties are in relation to health and safety and a case study on that. And then finally, just a couple of things to keep in mind when kind of working within your businesses and stay compliant. Next slide, please. So the principal health and safety legislation is the Health and Safety at Work Act 1974. It's a fairly old piece of legislation, but nevertheless, the key statute, and it sets out the basic health and safety duties of a company, its directors, managers, and employees. Section 2 sets out the duties of employers, so far as that they must ensure the health, safety, and welfare at work for all employees, so far as reasonably practicable. Section 3 sets out the duties employers have to non-employees in ensuring that the health and safety of others not in the employer's employment, so far as reasonably practicable. Next slide, please. So those are some of the duties that the employers have towards their employees and non-employees. In addition to the Health and Safety at Work Act, there are other statutes, and I've just set out some of the kind of key obligations here. So a business must provide a written health and safety policy. You must assess the risks to employees, customers, partners, and other people who could be affected by your business activities. You must arrange for the effective planning, organization, control, monitoring, and review of preventative and protective measures. A business must ensure that it has access to competent health and safety advice, and employees must be consulted about the risks to their health and safety. Next slide, please. So on to the case study. This is a real case which I've taken. I think it's a couple of years old now, before COVID. The defendant in this instance was Capstone Building Limited, and an employee was struck by falling masonry after a retaining wall failed as it was being backfilled with concrete. Capstone failed to appropriately manage the work that was being carried out at the site and failed to manage the welfare of employees on site. After the incident, the company went into administration and they were prosecuted for breaching Section 2 and Section 3 of the Health and Safety at Work Act. Now, before we move on to the next slide here, I thought it'd be interesting to get your opinions on what you thought the fine was in this particular case. Feel free to put it into the chat or unmute yourself and just have a go at picking a figure.
Is this the overall fine, Colleen, the quantum of the fine?
Correct, yes. So there was a fine that was issued by the court and prosecution costs as well for breaching Section 2 and Section 3.
I'm guessing but north of £1 million.
Okay. Well, next slide, please, Roy. They went to trial, so they lost any credit for any early guilty plea. They were fined £900,000 in order to pay prosecution costs of £60,000. So you weren't far off, Tim. I think that's a brilliant guess. Thank you. Next slide, please, Roy. So Section 7 sets out the duties that employees have. And employees must take reasonable care of himself and others in the workplace, and that they must cooperate with the employer as far as necessary. And next slide, please, Roy. Section 37 sets out the duties that directors have. And so a director, a company secretary, or a manager can be held criminally responsible for health and safety offences where the company itself is guilty of an offence, or the offence was committed with the consent or connivance of, or was attributable to any neglect towards the director or the manager. Next slide, please, Roy. A director convicted of a breach can be disqualified, and companies can purchase insurance to protect directors from the cost of civil damages and legal costs of defending proceedings. Next slide, Roy. Oh, sorry, one more slide. Okay, so this is another case study. In this instance, a resident fell more than 3 meters when his balcony collapsed, landing on a beach below. The defendant was Crystal Clear Properties, who were refurbishing a neighbouring riverside property, which included changes to that property's balcony, and it therefore required it to be extended to join that of the injured party's property. Sheets of plywood and plastic were used to temporarily infill the completed balcony framework prior to the toughened safety glass infills being fitted. Next slide, please. And the failures in this instance, sorry, Roy, next slide, please. Yeah. The failures in this instance are that, the defendant failed to take preventative measures, and therefore any measures taken were inadequate. There were no measures in place to prevent access to the balcony until the construction work had been completed. There was no construction phase plan. There was no specific risk assessment for using plywood or plastic as an interim measure, and plastic sheeting that had been used was an unsuitable material as it did not afford the injured party any protection. Now, before we do move on, again, in this instance, the director was sentenced, and I'm keen to get your views here on what you think the sentence was in this case.
Would be custodial for 6 months, something like that.
Well, yeah, not too far off. So he or she was, next slide, Roy, please. Imprisoned. Well, they got a 12-week prison sentence, suspended for 12 months, and also ordered to pay prosecution costs of £4,782. Onto the last slide, please, Roy. So I've just set out very quickly the law, gone through some cases of how the health and safety executive prosecute any failures. And I just wanted to end by sharing a couple of points which I think you should keep in mind. So the first is that penalties for breaches of health and safety legislation are steadily increasing. Even if a prosecution does not arise, simply being investigated can impact on an organization's morale and the morale of employees in the workplace. Prosecutions can damage the business's reputation, and frequently, if a business tenders for public contracts, there may be a question on the tender which will ask, do you have any criminal convictions, or has the business been prosecuted for health and safety offences, and the offences therefore may be disclosable and potentially a hindrance to getting further work in the future. Having a good health and safety record can help if something bad does happen. This is particularly useful if the health and safety executive decide to prosecute. You can make the argument to say this is an isolated incident, it's a one-off incident, you've generally been in business for, let's just say, 50 years and have never had an incident before or been investigated or prosecuted before, and it kind of just makes it look good and is useful for mitigation. And lastly, but I think is the most important point, seek legal advice immediately after an incident. You'll find when something happens, the health and safety executive or any other regulator, including the police, will probably turn up to site. They may shut the site down. They might decide to interview you and your employees. And I think it's really important to seek legal advice immediately. We, for example, are happy to have a conversation and advise clients in the outset if this does happen. So I think that's probably the most important point to keep in mind. That's all for me. Thank you for listening and your participation, and I will now hand back over to Roy.
Kaleem, thank you very much for your insight on that. So for this next portion of the webinar, we're going to be looking at whistleblowing, the subject of which is far too vast to go through in the limited time that we have. But this will hopefully give us an overview with the focus on health and safety in particular. So some of you who might be watching this or in the webinar today may be safety reps or stewards or HR. So you may have already been in a position where something that might appear to be whistleblowing has been reported to you, or if there's been some kind of wrongdoing or bad practice that someone has raised with respect to health and safety. In the vast majority of these sorts of cases, particularly if you're in those sorts of job titles I've highlighted, then these will no doubt typically be resolved between the worker and the employer, or between you and discussions with the employer. And while that ought to be the case, however, occasionally that isn't done, and that's where employees may end up having whistleblowing claims or complaints that they eventually raise. So what, just for the main focus for a quick moment, is whistleblowing? So that's the act where a worker may disclose information about wrongdoing in the workplace. Now, that disclosure typically is about the employer. So it could also be about a regulator, for example, the police or the media, but in the context of this is concerning the employer. So are workers allowed to whistleblow on the grounds of health and safety? Well, the simple answer is yes. Only in limited circumstances, though. And the reason I mention that is because whistleblowing is somewhat complex. That it's not just a simple matter of, oh, I've got something wrong with my employer, and I think it concerns a health and safety issue, and therefore I'm now a whistleblower. So the act in and of itself takes care of disclosure in the public interest on an issue that is on some of the factors that we've got here. So health and safety at the top, all the way down to an attempt to cover miscarriages of justice, damage to the environment, failure to follow a legal obligation, and so on. And what that in basic terms means is that if a worker is dismissed or suffers some kind of detriment for making such a disclosure, they can claim something like unfair dismissal. So that disclosure must be of information and not an allegation of the above without the relevant factual information. And as far as the public interest is concerned and how the courts interpret that, that's not entirely clear. But I think it's really important to note, for those of you who are watching this, is that although it's not an absolute requirement, that kind of disclosure is judged about it not being in good faith. So just because an employee may not give a statement or a disclosure in good faith doesn't mean it automatically fails. What matters principally is the motive for raising that concern, as opposed to whether that allegation is proved to be true. Therefore, to demonstrate good faith, you may have to show that your main motive was, for example, in this case, the health and safety of the worker or a third party, as opposed to some ulterior motive. So to give an example of that, I had a case recently of an individual who was a health and safety rep in a company, and an incident took place at some point last year, and he had raised some concerns to his employer. And he'd also drafted a report along with some recommendations for this particular employer. What unfortunately transpired is that instead of the employer taking these recommendations on board, the employer highlighted that there were some issues between it and the employee was eventually dismissed. Now, here is an example of where this person has noted some health and safety concerns, has raised a complaint, and has suffered a detriment, and in this case, it was dismissal. So it's somewhat unsurprising that when these facts and figures came to me, the red lights lit up, and we are now running a whistleblowing, detriment, and unfair dismissal claim. But these are the sorts of things that companies need to get right and need to react positively to, as opposed to getting defensive on. So moving on to this particular slide in terms of what to do when considering making a disclosure, or if we focus on a little bit more about why is it important to seek advice. Colleen mentioned about seeking advice before making such a disclosure on health and safety public grounds. The first thing that we can see here is do your best to exhaust all normal procedures, and I appreciate that exhausting normal procedures may eventually be to your own detriment. Where it may look like it's going that way, the first thing that I would always suggest or ask is there actually a whistleblowing policy in the company? So if you work in HR, or if you're in a leader or a manager, and you are advising a company or a small business, make sure that they've got a whistleblowing policy procedure. It's much better for your company to have a whistleblowing procedure, because you cannot expect everyone to know what you know if you're in HR. You can't expect everyone to know what you know if you're an employment lawyer or you're a health and safety professional in whatever capacity that comes in. So if there's something that can be transferable to leaders and managers and to staff in your workplace, that will definitely help as a whole, and that will definitely help individuals frame their minds as to if what they're actually going to be disclosing actually matches the threshold for what actually is a whistleblowing issue, or whether it's a grievance they can raise separately. But nonetheless, if for whatever reason those avenues fail, then as Colleen mentioned, it's definitely worth seeking legal advice. What you don't want to end up being in a situation of, one, if you're the employer or HR, etc., you don't want to be defending something that you don't think is whistleblowing, and in actual fact it is, and you're opening up your business to risk. And if you're an employee, what you don't want to be doing is shouting something is whistleblowing, beginning a claim, getting to a tribunal, for example, and then at that point seeking legal advice, and then it turns out it's not whistleblowing at all. It's often much more complex than what meets the eye. So businesses actively encourage your workers to use their internal procedures, and employees certainly actively look at your internal processes first, but by all means, if those avenues fail, then it's really important that you seek legal advice. Suffice to say, you might not feel that your employer is the right route for it if you're an employee. There are other avenues, or what are called prescribed authorities. If you work in England or Wales, then the Health and Safety Executive website is equally a good place to start, and it takes care of a number of workplaces. However, like Yemi, if you work in local government, local authority environmental health departments are often responsible for certain other whistleblowing activities. If you work in hospitality, for example, hotels, restaurants, if you have a shop or work in a shop, retail, leisure premises, nurseries, playgroups, schools, these are the sorts of places that local authorities can assist with. So, should concerns be raised openly or in confidence or anonymously? Most people naturally will want to do that anonymously, and one can't necessarily blame you for that. But if you work in HR, or if you're a leader or a manager and you're watching this particular webinar, I'd encourage you to actively encourage transparency within your workplace. One, because it means that you have workers who are ready to be open and honest about things that they see or witness or want to let you know about. And two, it certainly improves the morale within your workplace. So I'd certainly encourage you to do that as far as your staff is concerned. If you're a worker and indeed you've looked through your internal grievances and you're still concerned about that, or your line managerial process might be the issue and you may not have much confidence elsewhere, then again, I've talked about some other avenues or regulators that might be open to you, or indeed, when contacting the Health and Safety Executive, it may be the case that you can do something, that you can signpost to them your issues in confidence or indeed anonymously. By in confidence, I mean that you're able to state your name, but then just let them know that you don't want that to be disclosed, or anonymously, you let them know the issue, but do not disclose your issues at all. And before I hand over to Yemi now, I'll just highlight again a couple of checklists rather for you, if any of you are watching on your safety reps. One, make sure you've got your internal policies together. Two, if an employee brings a concern to you, have they consulted your whistleblowing policy? Have they gone anywhere else for advice? Is it something that can be resolved internally, or do you need to yourselves get external advice? You're also going to have to consider, particularly if it's a health and safety concern, if that potential issue may cause significant other issues elsewhere, or is a breach of law. So hopefully that helps. I'm now going to cordially pass on to Yemi, who will be talking on the subject of health and safety, starting off with the future. Thank you.
Thank you very much, Roy. Hello and welcome to What the Health is going to happen concerning the future of health and safety. So I'm just going to run through a few up and coming trends, points of consideration in the world of health and safety. I'd be really keen to afterwards hear some thoughts, or even during, if you like, on some of the topics I'm raising, very, very topical at the moment. I'm going to go through various things, the good, the bad, the ugly, really, concerning the future of health and safety. Some things work and are working really well. So working practices, less time in the office, more time at home. Other things might be an issue around regulatory burden. Will there be more or less red tape to businesses, and what will the impacts be for employers and employees alike concerning that? Even the ways we're working, spending less time perhaps doing health and safety training in classroom form and more online. So we'll explore all of that. And I just like to mention a short little thing. This presentation is being recorded in this particular moment of time. Things can change tomorrow, things can change next week, in a month, a year's time. So we have to be open to the fluidity and flexibility of an ever-changing landscape in health and safety. If we go on to the next slide, we'll explore the first few elements of that. So, widely reported even today, hot off the press, home working seems to be the future of health and safety, which all seems fine and well, but what is the impact to, especially employees, concerning their mental health, their physical health? According to the Royal Society of Public Health, it's predicted that half of the UK's workforce will work from home in the near future. quite a considerable change to even 5 years ago. What do we think are the key implications to mental health and physical health? I'd like to just reiterate one thing while I'm talking about mental health on this. It is part of health and safety. A lot of the time, and I hope I'm not teaching anybody to suck eggs, as the saying goes here, but a lot of the time when it concerns health and safety, people do not consider mental health and well-being, but it's huge. If you have a look at the Health and Safety Executive website, there are various guidelines and documents there. Companies are encouraged to implement stress management or mental health management, or whatever they may term it, in their policies. It really is part and parcel of health and safety, mental health, physical health. So in terms of home working, many businesses are embracing the idea of home working. You know, it provides flexibility, maybe it provides a better home work-life balance. But in terms of mental health, is there an impact in terms of checking in on employees, seeing how employees are faring, seeing how employees are physically, how they're looking? You can't sort of gauge these things. What is good practice? What should employers do to help employees when they're not seeing them every day? Maybe also even for new employees, thinking about that as well. You know, how much harder might it be for new employees to settle in, to get to know their colleagues, to build a rapport, to build trust. Even with respect to whistleblowing, that takes a lot of confidence and trust. But if it's not there because people are at home, maybe a bit siloed in how they're working, less of that kind of input and involvement, perhaps it makes things like whistleblowing a little bit more of a challenge, and it may do in future. Okay, so we're really witnessing a seismic change in how people are working because of this trend in working from home. Not to mention physical health. Musculoskeletal disorders are very common in the workplace. And a big thing about working from home is how is an employee's workstation looking? Are employers making sure that they are doing the proper assessments? So physical health, it's about maybe posture, the workstation, doing the correct assessment. And there's lots of guidance on this. There's the law, there's display screen equipment regulations, but employers need to make sure that they are looking after their employees at home, whether as well as the same way they would in the office, carrying out the same kinds of assessments. And then, of course, there's the use of technology. I've got this little image here. We're talking about Zoom, and we're on Zoom at the moment, Microsoft Teams, whatever it may be. All these things are great, but again, you know, is this the future for health and safety? Is this the future for how we want to conduct meetings? Is it helping? Is that virtual environment helping to improve, in particular, mental health? Or is it not, perhaps? And of course, maybe for a bit of humour, sometimes accidentally looking like cats can help lighten the moment during meetings, or perhaps not, as it was in this case. But yes, we need to think about the short-term, medium and long-term effects of this new working at home practice. Next slide, please, Roy. So I've mentioned on a couple of these things already, but just going into a bit more detail. So parental responsibilities. I'm a parent and I know exactly what it's like in terms of the impact on mental health. To begin with, juggling children who maybe are homeschooling and otherwise, or being distracted. You know, there's been many times we've seen wandering toddlers at the back of a Zoom meeting. I've mentioned about poor workstation setup, and that links, it does affect mental health, because if your physical health is poor, it can affect your mental health. Going into physical health, you might be working on a workstation that is not designed for prolonged use. Most people need a separate monitor. Most people work on a laptop. And the thing about working on a laptop is the head might dip forward or otherwise. Think about how you're sitting now and what kind of screen you're looking at. Is it suitable? Is it appropriate? Is your posture correct? Is your back in the correct alignment? Do you need additional support? Please do reach out to your managers and otherwise for the help that you need. They are obliged to make sure that you're legally obliged, of course, to make sure your workstation is adequate. Okay, and the thing about this, actually, the next point I want to mention is that blurred line between working from home and office work is, when does the day start? When does the day end? Is it possible that we are working longer hours due to this new working from home practice? That has an impact on both mental health and physical health. Are we taking enough breaks? Are we taking that designated lunch break? Is it harder to do that? Are we just eating at the desk? Again, posture, mental health, coming away from the desk. Some things to think about. Next slide, please. So really, in this bit, I'm going to just go through some key aspects, some interesting pointers concerning the future of health and safety. We're moving away from working from home, and we're just talking about some general aspects of health and safety in the workplace going forward. So a few quick pointers. The first box there is referring to e-learning. Okay, I mentioned in my introduction that we are seeing a trend where we are moving away from classroom learning. So all of the things that Colleen was talking about, you know, a lot of that is embedded in health and safety training, absolutely paramount in organisations. But as we move towards e-learning, I wonder how that might impact the future of health and safety. Might it be easier for some people to learn on the screen, or perhaps not? Many people might prefer to learn in a classroom. What might that mean? What might the impact be in terms of retention of information and carrying it out in the workplace? Might we see more accidents and near misses because training is that important? Okay, so some things to think about. We're seeing more courses conducted online than ever before. I certainly am within local authority. In fact, where I work, all of our training courses are online at the moment. The thing about online training as well is perhaps it is easier to learn and implement because you can kind of go at your own pace with a lot of the courses, instead of sitting all the way through a classroom feeding it's death by PowerPoint or otherwise. So perhaps there are some benefits there. Then my second box, I'm talking about EU exit. Yes. So what is the impact? As we know, we've come to the end of the transition period, okay? So chances are, in terms of my day-to-day work, there hasn't been a significant shift, okay? A lot of the EU law has been shifted into UK law. However, in order to implement these changes and implement the changes effectively in various workplaces and organisations, might there be additional expense involved or staffing to roll out new training policies, procedures, making sure everything is in alignment, you know, with any shifts that might have happened? Are policies and risk assessments up to date? And some employers are being urged to consult externally for professional advice to make sure that everything is as it should be, and that might be an additional cost as well. In effect, the question here, what the health? Might there be additional costs to ensure health and safety compliance in light of EU exit? We shall see. My last box there, I'm talking about regulatory reform. Now, it has been widely reported that regulatory reform is changing the landscape of health and safety. According to various think tanks, such as the Institute of Employment Rights, regulatory reform in health and safety is long overdue, okay? Especially of late, we're seeing less proactivity from health and safety professionals, local authority and otherwise. And what might the impact be in workplaces? Might it expose weaknesses in regulation? Maybe remote enforcement, like if the health and safety executive calls up employers and says, have you got your risk assessments up to date? How are things looking? Is that effective if they're not actually going out and physically looking at things, let alone local authorities, which aren't doing that as much anymore? So my last point here is on the future regulatory reform proposals might have on the future of health and safety. According to the Institute of Employment Rights and various other think tanks, regulatory reform to health and safety in the UK is long overdue. At the moment, the reduction in regulatory enforcement is leaving workers quite badly exposed to ill health and even death. And by way of background, about £100 million is lost to cuts to health and safety, has been lost to the health and safety executive in cuts in the past 10 years alone. So that's a big impact in terms of the work they do. So that is meaning that they're doing a lot more remote assessments and less time on site. Certainly for myself as a local authority officer, I'm spending less time on proactive health and safety enforcement. So this is potentially leaving a lot of workplaces exposed to bad practices and otherwise. So it's worth bearing in mind, a lot of the public, when surveys, would prefer and believe that there's more face-to-face on-hand stuff happening, whereas at the moment that's on the decline. So what will the impacts be? Will there be some long overdue regulatory overhaul? We'll see. And that's the end of my slides. Thank you.
Great, thank you so much. And I'm going to pass on to the next bit in terms of questions, feedback, or otherwise. Tim, you mentioned you had a question or a couple of statements. You're welcome to unmute yourself. Over to you.
Thank you, and well done, the three of you. That really was interesting for me. Has there been any significant later health and safety legislation away from, I think it's 1974, wasn't it, the Health and Safety Act that you mentioned there, Kaleem?
Yes, that is right. The Health and Safety at Work Act dates back to 1974. There has been subsequent legislation. It's the way I see it is the Health and Safety at Work Act is very general and broad and all-encompassing. The governments have, well, I guess subsequent regimes have introduced regulations specific to the construction industry. So you've had the CDM regulations, which have changed over the various kind of number of years. We've had the COMA regulations. So there has been subsequent regulations. Some of them are quite kind of like the Health and Safety at Work Act industry-wide. Some of them are sector specific. You know, we've got the Regulatory Reform Fire Safety Order, which governs fire safety risks, and you know, in the next year or so, we may have the Building Safety Act, which will come into force. But usually what I found is that any further legislation is kind of sector specific or aimed at a particular kind of industry.
Thank you. So the core health and safety legislation still is Health and Safety Act 1974 by the sound of it. That's the one that goes up in the headlines.
Yes, it's core. You've also got the Management of Health and Safety at Work regulations as well. There are kind of a few key statutes, but you know, I'd say that generally the Health and Safety at Work Act is usually the one that the HSE enforce under, and that's because Section 2 and Section 3 are so wide. You know, I mean, it says that you need to take measures to ensure the health and safety of your employees or non-employees so far as reasonably practicable. Now that is really wide. What is reasonably practicable? And that's where, you know, the health safety enforce, and then trials might take place in which you know, the defendant will have to, or the prosecution will have to prove that any measures taken were not reasonable, and the prosecution will have to disprove that. And so, generally speaking, the HSE usually enforce under those regulations. If it's an incident that involves the construction sector, they may enforce under the CDM regulations. If it's something to do with machine guarding, they may enforce under the PUA regulations. If it's something to do with lifting equipment which has failed and someone's got injured, they may enforce under the LOLA regulations. So there's, yeah, I mean, to summarize, the HSE have a vast kind of array of legislation that they can enforce under. But the Health and Safety at Work Act is probably, I'd say, the primary key statute.
Thank you.
Right. Thank you, Kaleem. Yemi, you got your hand up as well?
Apologies, hand up and now unmuted. Wonderful. So, rookie error. So I wanted just to add, in relation to Tim's question on latest changes since 1974, but linking it to some of what Kaleem was talking about in his slides on sentencing and fines. So I think it was early 2016, some sentencing guidelines came out, meaning that where fines might have been fixed for certain offences in the past, they're more proportionate to, say, the overall earnings of a business. So we're seeing heftier fines, larger amounts as well. So that, I think, had a big impact on the kind of consequences of poor health and safety in workplaces. Kaleem, have you noticed a lot of that in your sector?
Yeah, I think so. The 2016 guidelines were introduced because clients and judges were finding themselves in a position where you'll have a judge in Liverpool who will sentence a client or defendant, for £90,000, and then a judge in Swindon or London that will sentence a defendant for £10,000, and there was really no consistency. And so these guidelines were introduced to ensure that fines are proportionate, and that they act as a deterrent to ensure that businesses have good health and safety practices. And since then, I think the fines have just gone through the roof. The way the guidelines work, the fines are relative to the turnover of the business. They are structured for small, medium, large, and very large organizations. And if I think it's if your turnover is 50 million or more, you're considered a very large organization. And so the larger the turnover, the larger the fine, the more severe the injury, the greater the fine will be. So there's this kind of it provides the judges and as legal practitioners, us, with some kind of framework when it comes to sentencing and guidelines, which is always useful in the outset of an incident, because the client will ask, well, what's our risk here? What's the fine going to be? And now that we've got the guidelines, we can give some indication as to what we think the fine may be. Having said that, it depends on the judge that you have and what evidence is disclosed as well, and the quality of any witnesses if the matter does go to trial, which are always other considerations.
All right. Thank you both. I've got time for a couple more questions if anyone has any, or any feedback to give or comments.
I have a second question, but I'll see if anybody else comes through first.
Well, the sounds of things, you're welcome to ask Tim in the meantime.
Okay, thank you. On the whistleblowing element, Roy, it troubles me sometimes. I can absolutely see why it's there and it's really important, but I've had previous experience where anonymous whistleblowing claims arrived in a very big organisation, let's say to head office, and came to the view ultimately it was a vexatious one. It was just to make a nuisance of themselves, really. And I'd separate that well and truly from the really valid ones that should be paid attention to. I suppose my question is, can those sort of things be headed off? Or is there some sort of recourse to people who do make vexatious type claims that has everybody paying a lot of attention to it, and actually there's no real substance to it in the first place?
Indeed. Fair and very good question. So, of course, businesses have got a really difficult balance to strike. On the one hand, you want your employees to be open, transparent, and indeed honest in terms of the feedback or issues that they raise. But if in this specific context, you have someone who you believe is a toxic employee or vexatious in terms of the things that they have raised, and there is a a precedent set that this is happening, then think about what the threshold is as far as that good faith element that I talked about earlier. It's not that the individual must have raised something as an element of good faith. There must be some proven ulterior motive involved in terms of what the individual is raising. And if it's the case that you followed your whistleblowing procedure, it's happened time and time again, then there are avenues open for the business, all the way up to disciplinary procedures as well. And very much so. In fact, I acted for a respondent client not too long ago, where a vexatious employee, similar as you mentioned, Tim, raised a number of concerns, but eventually it turned out indeed that they were not only untrue, but he had his own vendetta against the individual to whom he raised the concerns about. And he was eventually dismissed. Yes, he brought a claim, but his claim was thrown out. So there are avenues indeed open to businesses.
Sure. And that's absolutely right, of course it is. But one I also think of was anonymous. And it's actually very difficult to feed back the outcome of the investigation to an anonymous source. So it doesn't make it easy sometimes, does it? Quite right.
Quite right. It's one of the pros and cons of it. The pro in that you maintain your anonymity, but the negative indeed is that as an employer, it's very difficult for you to give feedback. Or if individuals or witnesses aren't mentioned, it's very difficult for an employer to investigate properly, as you've highlighted.
Yeah. Thank you.
It's all really great points, Tim. Thank you. Anyone else before we close? All right, it doesn't seem so. Well, thank you all very much for joining in, those of you who have joined in live, and for those of you who are watching on demand, well, thank you very much for watching. For now, it's goodbye from Yemi.
Goodbye, thank you.
Bye, Yemi.
Bye-bye,
Tim.
Tim.
Goodbye from Kaleem.
Bye, everyone.
Bye.
And it's goodbye from me. Thank you.